In 2020, COVID hit the UK, and our government has spent billions and billions on furlough, on vaccines, on eat-outs to help out. And it's also spent actually billions more on medical protective equipment, or PPE, to protect NHS and care workers. It's also spent a lot of money on focus groups to test their policy and communication methods, whatever the law crack that means. But there have been stories flying around that the government has been sending some of this money to its mates. Quite a lot of money to its mates, in fact. A quote that's come out as a result of legal proceedings from the head of insight and evaluation for the Prime Minister's office is, "This agency is the one who are Dom Cummings' mates and hence getting all our work with no contract, but also spending much money on doing all our ridiculous groups." Well, given the fact that the head of insight and evaluation is clearly involved in focus groups, how ridiculous must these groups have been? But in some cases, the government's buddies have been less than gracious in the way they return the favour. PPE has been sent that was unusable, sometimes paying tens of millions of pounds to middlemen. Now, the scandal arises because most of these contracts weren't given out by government using what's called competitive bids, but instead just on the nod behind closed doors. And as a result, the public has pretty much no guarantee that the money was spent wisely. And the government also haven't published details of these contracts. Okay, so why is Lawcracker interested? A legal not-for-profit organisation called the Good Law Project has launched a crowdfunding campaign and hired lawyers to take the government to the High Court for their lack of transparency in the award of these contracts. And guess what, muchachas and muchachos? The Good Law Project has won. And ominously, they have more cases in the pipeline, which could be devastating to the government if they win those too. So what's going on? In the greatest period of crisis the world has faced in 3/4 of a century, has our government been ducking and diving like Del Boy and Rodney giving out contracts to its mates? Or is this just a case of whining lefty lawyers standing on the sidelines, criticising the people at the top because they're easy to aim at? Well, as some of you may have realised, that was an almost implausibly rhetorical question, providing two fairly exaggerated but pretty much diametrically opposed answers. And that can only mean one thing: it's law cracking time. So picture the situation. It's late February, early March of 2020. You're the government. You've noticed there's this COVID thing. Your scientists have been telling you for a few weeks now that it's a big deal. But it's now clear that it actually is a big deal, and the UK is not prepared. The NHS isn't ready in all kinds of ways. Specifically, there is inadequate protection for its workers who don't have enough face masks and aprons. In fact, we just sent a load of it to China, who seemed really keen to have it very quickly, although at the time we were a little confused as to why. But either way, we need millions of masks, and we need them yesterday, or tens of thousands of people may die. We also need help getting the messages across to the public about how to stay safe, and we need specialist consultants who tell us how to do it, and they need to be here by this evening working because this thing is spreading fast. Now, your advisors in the Department of Health and Social Care tell you, we can get you the equipment and people you need, but we need to do a tender process, and it'll take a minimum of a couple of weeks. But you don't have a couple of weeks, so you go through your contact list straight away, and you get people you know to help, and you get it done quick. That sounds plausible, right? Well, it's pretty much what happened. And it looks like a major player in that decision-making was Dominic Cummings, then chief advisor to Boris Johnson. Dominic Cummings, we remember that guy, don't we? He's the guy who went to Durham and checked his sites and saw the sites and doesn't work for the government anymore. A picture is gradually emerging that his friends and allies of the Tory party were being sent some of these contracts, including £250 million for PPE, most of which was the wrong PPE. Oh dear. Now, it's important to say here that if you're in government, there is nothing wrong with hiring your friends to do a job as long as you're sure that they'll give the best value and that other people can see that this is open and transparent, not just Because you're buddies. And how do you do that? Well, you follow the rules which are set out in the Public Contracts Regulations 2015, or the PCR. And those rules say you have to use a competitive bidding process. Different companies make their offers, and government picks the best combination of quality and price. Now, that means that if you do end up picking your friends, you can't be blamed for it, because you can show that it was because they happened to be the best, not because you own a part of the same racehorse or you meet with the Freemasons and Hillary Clinton doing whatever elitist lizard Illuminati stuff you're up to, which, for the avoidance of doubt, Lawcracker does not advise you to do. So you do bids, and nobody can complain because it's all obviously legit. But here's the thing. That bidding business, while it may be transparent and it may get good value for the public, it does. It's a process that takes time. Usually months, weeks, if it's fast-tracked. And everyone remembers, don't we, the urgency about everything to do with COVID and panic in the spring and summer of last year and about getting back to normal. How naive that was. So there probably wasn't time to do competitive bids there for at least some of these things, right? So in fact, there's a get-out clause in the rules. They can give what's called a direct award if it is, quote, strictly necessary, where for reasons of extreme urgency brought about by events unforeseeable by the contracting authority, the time limits for open or restricted procedures or competitive procedures with negotiation cannot be complied with. Wow, that's more law than Lawcracker's ever had to remember. But you then have to be very transparent about what you've done, because avoiding a tender process is not the proper way of doing it. And the government's own guidance on this makes it clear that transparency is super important in all of this. Transparency and accountability of public service delivery data builds public trust and confidence in public services. Isn't this, Lawcrackers, a time when public trust and confidence in our public services, in our government, perhaps could not be any more important? So how should the government be transparent? Well, the rules say it has to publish as much information as it can be expected to do about what happened, so the public can see it. First and foremost, the government has a legal requirement to do so in a contract award notice, which ends up on the web, freely available for people to view. And the government's own guidance says that it should also publish contract terms in more detail, basically the whole contract with maybe some details removed, within 90 days. Now, this stuff about being transparent immediately is really important, because this type of direct award without a tender is already a massive exception, which for these purposes is only necessary in an emergency situation. The safeguard is you make sure that everyone can see what you've done after the fact. And what makes this even more sensitive in this case is this isn't a few £100,000 worth of contracts, it's several billion. So what did the government do in 2020? Well, sadly, they didn't seem too concerned about showing the public what they'd been up to. They gave 10.5 billion in contracts without tenders, but then didn't make them public within 30 days in most cases. What most cases means was only uncovered in legal proceedings much later. And it got worse, because in some cases, the people they were giving these contracts to were not only friends or former Conservative Party colleagues, but they made a lot of these agreements without formal contracts, just on the basis of an exchange of emails. And a lot of these people who were supposed to provide goods or services screwed up. And when you screw up over 200 million quid's worth of PPE in a pandemic, the chances are people will die. So the news and rumours began about cronyism. Cronyism, well, is basically what posh people call jobs for the boys. But the government, as of the mid part of last year, didn't feel so much pressure to address most of those rumours, because they still hadn't published the details of most of the direct awards anyway at that point. And it doesn't look like they were that coordinated or organised in terms of knowing exactly how much they'd spent themselves. But these things have a habit of coming out. And the grubby headlines were as follows. There was a neighbour of the Health Secretary, Matt Hancock. You remember Matt Hancock. He's that guy who cries on TV, not very convincingly. That neighbour was given a contract to supply millions of pounds worth of medical-grade plastic vials. He was a pub landlord who had a company making plastic boxes. And he denied having had contact with Matt Hancock before the contract was awarded. Until the WhatsApp messages came out. Well, law crackers, at the time that we're filming this, it has neither been confirmed nor denied that the WhatsApp messages occurred in a group for an upcoming stag do, or where that stag do was going to happen. Rome, Vegas, Blackpool. In yet another slap in the face for the principle of open government, the location has never been revealed. In fact, this transaction was allegedly part of a VIP channel for fast-track approval of Tory friends getting contracts on the sly. That is an allegation. At this stage, it's probably at best unproven, at worst rumour. The logical thing to expect might have been at that point for some of the companies who'd missed out on contracts because they hadn't been invited to bid to come forward. But they didn't, allegedly, because they themselves were scared of getting blacklisted for future government work. Objection calls for speculation, I hear you say, young law crackers. Well, is that speculation? Yeah, technically it is, but this isn't Suits, it's Law Cracker, and Law Cracker says speculation is okay. Just be transparent about it. See what I did there? So at this point, enter the Good Law Project and a group of 3 MPs from Green Party, the Lib Dems and Labour, unsurprisingly not from the Tory party, and they decided to do something called a judicial review. So what's judicial review? You probably heard the phrase before, but you might not know exactly what it is. It's a way of challenging when government gets something wrong. But it's hard to bring a judicial review, it's expensive, and you have to be quick. If you don't do it within 30 days, the chances are the court will tell you to get lost before you even start. If it's that important, so the principle goes, you'll get in quick. And that's to stop the courts getting clogged up with people just complaining about governments after the fact, because let's face it, government always does things we don't like. You also have to show that the government's action was a seriously bad one, not just a decision that you didn't agree with. For example, if they acted outside their powers, disobeyed their own rules, or what they did was so stupid and so incorrect, no reasonable person would have done it. Who are these characters then, the Good Law Project? Do they know about this judicial review stuff? Well, the answer is this: they know a lot more about it than Law Cracker does. They launched 3 successful judicial reviews of the government's handling of Brexit, and they are run by this guy, Jolyon Maugham, who is actually a tax barrister who, before running this organisation, was in this specialist barrister's chambers. He is a QC, which means he is a very posh barrister with a wig. It means he's kind of got the seal of approval from government as somebody who's very good at their job. We are talking about an area of law where, if he was a tax lawyer at that level, £1,000 an hour is probably the norm. The Good Law Project, even if it pays him a salary, is like volunteer work compared to what he could be doing. And when Jolyon Maugham gets a bee in his bonnet, you don't want to be in the crosshairs. This is a guy who sued a law firm and won when he was a student because they refused to employ him as a temp because he turned up for work and he wasn't a woman. The work he is doing right now makes him one of the UK's most significant lawyers, perhaps going back several years. Now, the Good Law Project says that 3 separate contracts to companies which had no background in the sale or manufacture of PPE in particular raise massive questions. And these are subject to ongoing proceedings. And the total value of just these 3 contracts, the bargain price of £400 million. Now, that's 27 million Pfizer vaccine jabs, or 133 million Oxford vaccine jabs. See? One of many reasons Law Cracker recommends you to buy British. Now, the Good Law Project also argued that there was evidence of not only not publicising these other directly awarded contracts, but that it appeared to be a calculated policy of deprioritising the announcements, which sounds to Law Cracker like they were being accused of actually trying to conceal them. Now, the government's approach throughout has been pretty dismissive, bordering on aggressive. And to start with, it said that the Good Law Project didn't even have the right to bring this case because it wasn't a company who'd lost out on the contract. Basically, they were saying, what are you even doing here? You haven't lost anything. But isn't that just like saying that you should never report a crime to the police unless you personally were the victim? It's nonsense, isn't it? Now, surprise, surprise, when billions in contracts, which should have been made public, weren't available for them to see, the High Court judge was pretty unimpressed with the government trying that school playground BS. The government then went on to claim backlog and unprecedented times, which is not massively unreasonable, is it? Because it was a hectic time, but it also said that these contracts were in the process of being announced and would have been anyway. As it happened, many of them were miraculously made public as the deadlines for the judicial review got closer. It said it would have done that anyway, but the judge was unimpressed with that too and said that basically these proceedings were the reason that they had acted or begun to act quickly. Now, the government also claimed that it had managed to issue the contract award notices, those CANs, within 30 days for 28% of the contracts for the public to see. And hang fire on that point, because let's see what happened to that 28% number at the conclusion of the case. And as for the judge, well, he did some judging and he was not very pleased with the government. He pointed out that the government had had many chances before the case reached the final hearing to simply promise to disclose the contracts within a certain time in the future, not even there and then, and this would have avoided the need for it to even go to court, which ended up costing the taxpayer hundreds of thousands of pounds for government lawyers alone. He also said that it was blindingly obvious that the work of the Good Law Project was the reason that the government had got their skates on in the first place and was getting these things finally published. However, he did say that the Good Law Project had overcooked its case a bit, saying that there was a conspiracy to slow these contract announcements down and deprioritize them wasn't a credible suggestion according to the evidence, so said the judge. So the judge made a formal declaration that the government had messed up. He didn't force them to make the remaining announcements they still hadn't caught up with because they were by then on a path to clear the backlog. But so the judge could make the final declaration about the number of times they'd missed that 30-day deadline, the judge asked the government for the final figure. Now remember, they'd already told the court within 30 days for 28% of the contracts, except what they'd told the judge wasn't true. They had actually missed the deadline in all cases bar 3%. Lawcracker once got 3% on a school chemistry test. His teacher, Dr. Yates, formerly of the Cambridge University water polo team, was most displeased. A monkey with a pencil could have done better than that, Cottrey. Harsh. But in my defence, this was way before Lawcracker, and I wasn't in charge of billions of pounds of public money. In a depressing twist in this sorry and disgustingly expensive tale, Boris Johnson would go on the record in Parliament just 2 days later, despite that admission, and say to the country this: all the details are on the record. Boris, you've just been taken to the High Court 2 days ago. Yep, you spent 200 grand on lawyers to get there. You lost. There are another 100 contracts still not publicised. It's just a few billion quid. But you say all of them are now on the record to Parliament and the nation. Maybe we'll get an apology, maybe we won't. This is not a Prime Minister who's particularly used to accepting that he's been wrong about something as simple as facts. Now, the Good Law Project had this to say: government not only misled Parliament and placed inaccurate information before the court, it has misled the country too. So what's the outcome after all that legal wrangling? Well, we know about some contracts that we didn't know about before. Well, partly, but actually the interesting thing here is what will come next. This is the first major strike in the Good Law Project's search for something more. Cronyism is perhaps the nicest word that could be used, but they would clearly love to find something more, something closer to corruption. Now, what exactly the Good Law Project are aiming for is perhaps pretty vague. Maybe they're not quite sure yet because they haven't found it, but the first stage is this. They have finally flushed out the details of these contracts, and that could be just the beginning of a much larger series of attacks. But there's one thing that's for sure. The Good Law Project's boss, Jolyon Maugham QC, has certainly come a long way since he sued a law firm for not giving him a job, and Lawcracker for one suspects that there's no way he's going to be stopping here. This was the Lawcracker. Tell me what you think in the comments. Is this really corruption? Are we going to see more cases like this? Is this just the tip of the iceberg? And are lawyers like the Good Law Project a good thing for society, or are they just a bunch of liberal troublemakers? Guys, I have to tell you, we just got to the grand total of 100 subs on YouTube. Lawcracker thanks you. And you. And oh, you again. Hello. Now, the legal online press are also starting to link to Lawcracker on some of the different platforms. And that's really as a result of the interest and enthusiasm and the word that you guys have been spreading. Guys, I want to thank you so much for being part of this adventure that Lawcracker is on at the moment and supporting the channel. If you're new to the channel, there is this subscribe button on one of these sides. And also, please consider pushing the bell so that the new videos come through. There are a couple of other videos on COVID law, vaccines and lockdown and those types of things. And please tell me what you think. Finally, if there's a topic that you think that Lawcracker should be covering, please let me know. And who knows, it may get law cracked. Peace out.